I appear for the claimant.
Yes, who is appearing for the...
May it please, my lord?
Yes.
A.I. Adebayo. I announce my appearance for the first and second defendant, sir. Applicant. With me, my lord, sir.
Yes.
And my other senior colleagues, F.T. Shotikare.
F.T.
Shotikare.
Yes.
And Jimo Balogun, Esquire.
Okay.
We are most grateful, sir.
You're welcome. Yes. This is my ruling or judgment. First is the court's decision on the preliminary objection.
As the court pleases.
Firstly, by way of a preface, the law is that a reply on points of law is meant to be just what it is, a reply on points of law. It should be limited to answering only new points arising from the opposing brief. It is not meant for the party replying on points of law to re-argue its case or bring in points it forgot to advance when it filed its written address. It is not a forum to engage in arguments at large. Alternatively put, a reply on points of law is not meant to improve on the quality of a written address. A reply brief is not a repair kit to correct or put right an error or lacuna in the initial brief of argument. See Mosier and others versus Mbamalu, Musakoni Limited versus Aspinel, and Arulogun and others versus Abolo Injo and another. The first and second defendants reply on points of law by virtue of the repetitive submissions, contentions, and reiterations, cascading the entirety of their reply on points of law is accordingly discontinuous. The first ground of the first and second defendants' objection to the claimant's suit is that there is already pending before the Owerri Judicial Division of this court in suit number NICN OW/66/2019 between Comrade Ekwem Chinedu and others versus Comrade Ibrahim Khalil and others, filed on 16 September 2019, in which the claimant in the suit are already seeking the same reliefs being sought before this court. It is to the first and second defendants, this constitutes an abuse of court process. The parties in suit number NICN/OW/66/2019 are Comrade Ekwem Chinedu, Comrade Onwachu Henry, and Comrade Ugala Uzoamaka Ugwezi, who are claimants, and Comrade Ibrahim Khalil for himself, and as representing all national officers of Nolge, whose tenure of office commenced on 24th March 2015. Nolge Comrade Chikwemeka Agwoye, Comrade Victor Adebayo, and Comrade Nanpak Miri Njemiri for himself and as representing the members of Nolge who are the defendants. Claimant in the instant case are members of the second defendant in suit number NICN OW 66-2019. The first defendant in suit number NICN OW 66-2019, who was third defendant in suit number NICN OCA 44-2019, is now deceased and struck out from the list of defendants in this suit and replaced by Adigwe Chikwelu Williams as third defendant. Second defendant in suit number NICN OW 66-2019 is the second defendant in suit number NICN OCA 44-2019. From the narration above, it is clear and evident that the claimants in suit number NICN OW 66-2019 are different from the claimants in suit number NICN OCA 44-2019, even though both are members of Nolge, but from different state chapters or branches of Nolge. This, in my respectful view, is as well, because election matters and the determination of the same by law are sui generis. That is, they are of its own kind. It cannot be expected, as submitted by first and second defendants, that all the parties in election or tenure matters or such other matters at, say, Kaduna, Imo, Ondo, Anambra state chapters must all be the same and subsumed into one trial. See Wokocha versus Chinenye, Ike, and others. This is more so where the Nolge Constitution provides that the state chapter officers shall perform similar duties as their national counterparts at the state level. I do not subscribe to the nebulous argument of the defendants that the parties in the instant case and the parties in suit number NICN OW 66-2019 are entirely one and the same, and I so find and hold. This ground of objection is rejected and accordingly dismissed. The first and second defendants' second ground of objection is that the claimants did not comply with the condition precedent contained in Rule 5, Sub 5A of the Nolge Constitution by filing their appeal after the 30 days of the occurrence of the event. That is elongation of tenure of elected officers of the Union. To the defendants, the 2-year tenure extension granted to all officers of the Anambra State Council commenced in December 2017 and ended in November 2019, to the knowledge of the claimants. And it was only at the end of the said 2 years extended period that the claimants deemed it necessary to institute this action. To the claimants, the main crux of this suit is the continued illegal stay in office of the first defendant, who, as a private to the judgment of this court on 11th July 2019 in suit number NICN OW 36-2018, still continue to violate the orders of this court by holding on to office as the president of Nolge, Anambra State. The subsisting position of this court are stated in Comrade Ike Anyanwu and two others versus Comrade Eze and two others, delivered suit number NICN OW 36-2018, delivered on 11th July 2019 per JS Galadima J, regarding the purported Rule 5 Sub 5A of the Nolge Constitution 2016, is that the resolution by the purported Special National Delegates Conference cannot supersede the provisions of the Nolge Constitution, even prior to such resolution being registered by the Registrar of Trade Union, pursuant to Section 29(1) of the TUA 2004. That even assuming the resolution were even produced at all, the answer by the authority of Martins and others versus Kolawole, the citation is in the ruling, the answer would still be in the negative. The circumstance, there is no valid condition precedent or at all requiring the claimant's compliance with. This ground of objection is rejected and accordingly dismissed. The third ground of objection is whether, in view of the serious dispute of facts, it is correct for the claimants to have commenced this suit by originating summons. And if not, what is the effect? The defendants urged the court to strike out this suit on the grounds that this action is not properly constituted, having been commenced by a wrong procedure, and as such robs the court of the jurisdiction to entertain the matter. This is not the law. The law is that pleadings should be ordered. His Lordship Suleiman Galadima JSC, delivering the late judgment on Suleiman Atago versus Mr. Ibiso Nwuche and others, the citation is in the ruling, explained the correct position of the law in this words. I'm quoting Justice Galadima JSC. The general principle of law, as I understand it, is that where the court comes to the conclusion that the action ought not to have been commenced by originating summons, it shall proceed to order pleadings. Where, however, nothing will be achieved by an order for exchange of pleadings, an order of pleadings will not be made. This is the current judicial thinking as stated by the Supreme Court in Emezi versus Oswagu. The citation is in the ruling, close of quote. It is pertinent to note that Emezi versus Oswagu Supra comes in only where nothing will be achieved by an order for exchange of pleadings, in which event an order of pleading will not be made. Furthermore, the rules of this court are quite specific that, I'm quoting, where in the opinion of the court, a suit commenced by originating summons raises substantial issues of and dispute of facts, the court shall not strike out the matter, but may order its conversion to complaint and direct the parties to file and exchange pleadings and conduct the trial of the case in accordance with the rules of the court governing trial. Close of quote. See Order 3, Rule 17, Sub Rule 2 of the NICN Rules 2017. The concurring judgment of Akinton, JSC, in Deyelu II and others versus Oyewumi and others, citation is in the ruling, confirms this as the settled law. In his lordship's words, I'm quoting Akinton now, the law is settled that where there are disputed facts, such actions could not be initiated by an originating summons. Similarly, I believe and hold that the proper order a trial court should make, where it finds that the action before it was wrongly commenced by way of originating summons, is to order pleadings and not to dismiss such action or pronounce on the merit of the case. See, close of quote. See also Silvanus Eze versus University of Jos, where his lordship Rose Vival, JSC, delivering the lead judgment said, I'm quoting Rose Vival now, so once a suit has been filed by originating summons and it becomes obvious that facts are in dispute or the proceedings are likely to be hostile, the writ of summons would be ordered. Close of quote. The defendant's argument in paragraphs 3.35, 3.36, and 3.37 of their written address that the claimants in their originating summons formulated the 3 questions for determination and sought 7 distinctive reliefs by way of declaration and injunction, that the said originating summons is supported by a 32-paragraph affidavit and 6 exhibits that calls for a lot of scrutiny. The defendants did not specifically or distinctly draw out which items that cause for a scrutiny. I looked through the averments in these paragraphs. While it is true that there are statements of facts that would require clarification if they are denied by the defendants, they are, however, not averments that go to the substance of the question posed by the claimants for interpretation. It must, however, be noted, as heard by the court, by this in Oyebola and others versus FAAN, that the interpretation of documents is not the function of a witness. It is a function of law meant for the court. Close of quote. The questions raised by the claimants for determination at the risk of repetition will reveal that they all hinge on tenure extension, resolution of Nolge at Akure, on reviewed constitution of Nolge at the conference held on 13th October 2019. I am satisfied that this suit was appropriately commenced using the originating summons procedure. Accordingly, I hold that this suit is competent. As such, this court has jurisdiction over it. On the whole, there is no merit whatsoever in the preliminary objection of the defendants. It fails, and so is hereby dismissed. I now turn to the merit of the originating summons. This is my decision on the originating summons. The merit of the originating summons throws up a number of issues, including some preliminary cases. For instance, the claimant's reply on points of law is a rehash of their main submissions or brought up new things that were not conversed in the main address. By law, a reply on points of law is meant to be just what it is. That is, a reply on points of law. It should be limited to answering only new points arising from the opposing brief. It is not meant for the party replying on points of law to re-argue its case or bring in points it forgot to advance when it filed its final written address. The effect of non-compliance is that the court will discountenance such a reply brief. See Arulogun and others versus Abolo Imbo. The citations are in the judgment. Order 45, Rule 3, Sub Rule 1 of the court rules stipulates that where any unreported judgment is relied upon, the certified true copy shall be submitted along with the written address. And in Major General Kayode Oni, retired, and 4 others versus Governor of Ekiti State and another, this is what Her Ladyship Augie JSC said. I'm quoting Justice Augie JSC now. It is an elementary principle, very elementary, that counsel who want the court to make use of authorities cited in court must provide the name of the parties, the year the case was decided, and where the case is reported, name of the law report, the year, volume, and page must be cited. But if the said case is unreported, counsel must provide the court with a certified true copy of the judgment sought to be relied upon. Cited Chidoka and another versus First City Finance Company Limited and Ugo Ngadi versus FRN. What all of this means is that the claimants do not want this court to use Nolge Kaduna State Branch and others versus Adamu Alhaji Sani The said case shall accordingly be discountenanced for purposes of this judgment. And I so hold. The claimant's case is hinged on the interpretation of Rule 5.1, 2, and 3 of the 2005 reviewed Constitution of Norway, and Rules 5, 2, 3, 4, 12, sub 6, and 21, sub 4A of the 2016 amended Constitution of Norway. Rule 5, 2, and 3 of the 2005 Norway Constitution. The Constitution shall be deemed to be the basis of the contract between the members to establish and operate the union. And no new rules of the Constitution shall be made, or any rules altered, amended, or rescinded unless agreed to by majority votes of members in secret ballot at the National Delegates Conference of the Union. The key question before this court is whether there is provision anywhere in the 2005 or 2016 Constitution of Norway for tenure elongation from 4 years to 6 years, and whether officers of Norway have the legal right to continue to hold office or administer, manage, and direct the union at any level beyond the 4 years term to 6 year term to 6 years. The first and second defendants maintained that a community reading of Rule 5.1.3.4.5 of the 2005 Norway Constitution and Rule 6.1, sub 1, 3, 4, and 5 of the 2016 Norway Constitution had closed and invested the Special National Delegates Conference with the powers and authority to extend the tenure of the officers. That may be the reason why the first and second defendants stated in paragraph 7 of their counter affidavit in opposition to the claimant's originating summons dated 4th November 2019, the first defendant and other state officers of Norway in Anambra State, like all others of the Union, were duly granted a 2 years extended period to remain in office by the Union, and which extended grace period (2017). The interpretation of documents is not the function of a witness, as I stated earlier. It is a function of law meant for court. See Ambassador DCB Wana versus National Intelligence Agency and 2 others. The citation is in the judgment. Whether a 2-year grace period is grantable in terms of tenure of office is a function of law and not the business of first and second defendants. And I so hold. Rule 10 of the reviewed Constitution of Norway 2005, under which the first defendant was elected as Anambra State officers and members of the State Executive Council of Anambra State branch of Nolge on 10th December 2013 for a second term of 4 years tenure in accordance with the 2005 Nolge Constitution elapsed on 9th December 2017. I critically examined the reviewed Constitution of Norway 2005, and I did not see any provision for tenure elongation of 2 years therein. Incidentally, I did not see any 2-year tenure elongation in the purportedly amended Norway Constitution 2016 either. The law is established that tenure of office is sacrosanct. In Marwa and others versus Nyako and others, the Apex Court heard per Onogen, JSC, as he then was, that over the years, the Supreme Court has devised guidelines to the interpretation of not only statutes, but most importantly, our constitutional provisions, including some famous rules of constitutional interpretation propounded by Obaseki, JSC, in the case of Attorney General of Bendev State versus Attorney General of the Federation. The citation is in the judgment as follows. 1, effect should be given to every word used in the Constitution. 2, the construction nullifying a specific clause in the Constitution shall not be tolerated unless where absolutely necessary. 3, a constitutional power should not be used to attain an unconstitutional result. 4, a constitutional provision should not be construed in such a way as to defeat its evident purpose. And as to whether, close of quote, and as to whether the reliefs sought in this suit can be maintained against first defendant and or persons who are not parties to the suit, it is the law that it is the prerogative of a plaintiff to determine the defendants in a suit. See EcoBank PLC versus Metu and others. And it is the pleading of plaintiff that would determine the liability of such a defendant or each defendant. So whether or not the claims of the plaintiff will be established is a matter to be determined at the trial. In Nyako versus Adamawa State House of Assembly and others, the Supreme Court heard per Sanusi JSC does. I'm quoting Justice Sanusi now, JSC. Quote, again, one cannot lose sight of the fact that no court has the power to elongate the period of tenure of political office holders, which was enshrined in the Constitution, which creates that office, such as president or governor of a state. Any attempt to do so is unconstitutional and will lead to a chaotic situation and cause gross injustice, or may lead to political unrest or uproar. This court, in its several of judicial authorities, was emphatic on its lack of power to elongate tenure of office of a governor. For instance, in Marwa versus Nyako, the citation is there. This court, while interpreting the provisions of Section 180, Sub 1 and 2A of the Constitution of the Federal Republic of Nigeria, 1999, stated that provision has prescribed a single term of 4 years and another 4 years for second term, which cannot be extended, expanded, or increased with even 1 day. No court in Nigeria, therefore, has power to extend such period or tenure. Also in Ladoja versus Enoch, this court, that's the Supreme Court, also while considering the purport of the same provisions, stated that the 1999 Constitution as amended did not grant it the power to grant an extension of tenure to a governor who has been improperly impeached. It held that to hold otherwise amounts to reading what is not in the said Constitution, close of quote. It is most obviously very certain to me that the second defendant, being a union functioning under the third tier of government, adopted the 4-year tenure of 2 terms in line with the same tenure regime at the federal and state government levels. Be that as it may, what is certain is that the reviewed 2005 Constitution of Norgay, under which the first defendant was elected with his executive council members by law, entitled them to a 4-year tenure of 2 terms and no more. The donation of 2 extra years to the first defendant and his executive council by Norgay at Akure on 13th October 2016 is patently ultra-virus, their constitutional or whatever powers. It's illegal and as such unsustainable, and I so hold. A court of law will not allow a party who committed an illegality to benefit therefrom, so that the court will not promote injustice. See Dahiru versus Ahmed and Co. See Katagum and another versus Mimei. See Nasir versus Berini, Beirut Riyadh Nigeria Bank Limited. The citations are in the judgment. It does not therefore lie within the competence of the Special National Delegates Conference to overwhelmingly suspend Rule 13 sub 6A of the 2005 reviewed Constitution of Norgay and capriciously amend Rule 21 sub 4A of the 2016 Norgay Constitution to achieve a precocious end. Marwa and others versus Nyako and others held that a constitutional power should not be used to attain an unconstitutional result. The attempt by the Special National Delegates Conference to tamper with the 2016 amended Constitution of Norgay, to tinker with Rule 21 sub 4A, which provides that, I quote, all national, state, and local officers shall be elected to serve for a period of 4 years at a time, close of quote. In my humble view, tantamounts to improperly moving or shifting the goalposts in such a way that will be a disadvantage to the claimants in this suit, and I so hold. The extension of 2 years by defendants to the 4-year tenure stipulated in the 2016 Constitution of Norge is ultra-virus, therefore unconstitutional, and I so hold. The law is tried that you cannot put something on nothing and expect it to stand. See Okosa versus Comwo and others. The citation is in the judgment. On what is the legal effect where an act is declared null and void, the law as stated by the Supreme Court in the case of Adefulu and others versus Okulaja and others, per Ogundare, JSC, is that where, I'm quoting Justice Ogundare, JSC now, quote, where an appointment is declared null and void, all it means is that the appointment was never made, and all acts of the purported appointee when he de facto had the appointment are unlawful, null and void, and of no effect, close of quote. See also the case of Ladoja versus Inek, wherein the apex court heard per Oguntade JSC that, I'm quoting Justice Oguntade now, it is settled law that when an act is declared null and void, the position is that from the angle of the law, the act never took place. It is completely wiped off and considered as extinct and deemed never to have existed, close of quote. In McFoy versus UAC Limited, Lord Denning said, and I'm quoting Lord Denning now, if an act is void, then it is in law a nullity. It is not only bad, but incurably bad. There is no need for an order of the court to set it aside. It is automatically null and void without much ado, though it is sometimes convenient to have the court declare it to be so, close of quote. The claimant had argued that by Section 29 of the Trade Unions Act, (2004), Rules 5, sub 2, 3, 4, 5, 6 of the 2016 amended Constitution of the Norge, that any amendment or alteration of any of the provisions of the Norge Constitution can only become effective upon the approval and registration of such alteration or amendment by the Registrar of Trade Unions, and that there is no provision under the 2005 Norge Constitution which regulated the activities of the first defendant from the election on 10th December 2013 to 21st March 2017, when the 2016 Norge Constitution came into force, empowering any person, officer, or organ of the union to elongate the 4-year tenure of office provided for in the Constitution to 6 years. The status of a trade union is conferred by law, as being listed in the third schedule to the TUA, or conferred as a result of the Trade Unions Act, or conferred as a result of the registration by the Registrar of Trade Unions. Section 28, sub 1, 2, and 3 of the Trade Unions Act, Amendment Act 2005, which is in pari materia with Section 29(1) of the Trade Unions Act 2004, provides that, quote, 1, subject to this section, the trade union may alter its rules by any method of doing so provided for it by its rules. But no alteration of the rules of a trade union shall take effect until the alteration is registered. 2, the registrar shall not register an alteration of the rules of a trade union if, as a result of the alteration, A, the rules of the union would cease to contain provisions with respect to the various matters mentioned in the first schedule to the Act. B, the principal purpose of the trade union would cease to be that of regulating the terms and conditions of employment of workers. 3, an alteration of the rules of a trade union shall, if the rules of the union so provide, come into effect on a date later than the date of which the alteration is registered, but shall otherwise come into effect on the date on which the alteration is registered. Granted, of course, that the second defendant can amend its constitution, the pertinent question to ask is whether, by Section 28(1) of the Trade Unions Act as amended, the purported alteration by the defendant's Special National Delegates Conference, dated 15th November 2016, registered. I do not think so. The assertion by one comrade Ayodele Emmanuel, Nolge National Organizing Secretary, in the counter affidavit in opposition to the claimant's originating summons, dated 4th November 2019, at paragraph 9 thereof, that their resolution to alter the rules was subsequently approved by the Registrar of Trade Unions via the letter dated 13th December 2016, that's exhibit number C3, is not a true reflection of the said document. What the Registrar of Trade Unions stated in paragraph 3, lines 6 to 8 of exhibit NDC 3, dated 13th December 2016, is that I'll take that again. What the Registrar of Trade Unions stated in paragraph 3, lines 6 to 8 of exhibit NDC 3, dated 13th December 2016, is that, and I'm quoting, your constitutional amendments will soon be approved, if the requirements stipulated in the first schedule of Trade Unions Act Cap T14 of 2004 are met. Aside not showing any evidence of compliance with the stipulated preconditions for approval by the first and second defendants, they also failed of the purported alteration as required in Section 28 sub 3 of the Trade Unions Amendment Act 2005 by United Geophysical Nigeria Limited and others versus Mosheshe. The Court of Appeal said, I'm quoting now, the law is settled that when a law makes provision for the procedure of doing an act, non-compliance renders the act done null and void, close of quote. See also Unity Bank versus Sokoto, Riemann, Rural Development Authority and another, and Onje and another versus Mark and others on that aspect of the quotation. I earlier heard that the defendants do not have the rights to donate 2 additional years to the 4-year tenure stipulated in the Nolge Constitution 2005 and 2016 as reviewed or amended or at all. The answer to question C, whether the provisions of the Trade Unions Act and the 2005 and 2016 Constitution of Nolge granted the defendants the power to pass or issue any resolution elongating the 4-year tenure of office to 6 years, in my considered view, is a resounding no, and I so hold. I accordingly answer question C, posed in favor of the claimants, and I so hold. Given the answers to the 3 questions posed by the claimant and the reasons adduced thereby, I rule this matter in respect of the reliefs claimed. Relief 1 is granted. Relief 2 is granted. Relief 3 is granted. Relief 4 is granted. Relief 5 is granted. Relief 6 is granted. Relief 7 is granted. Judgment is entered accordingly, and I make no order as to cause.
As the court pleases.
As the court pleases.
As the court pleases.
You're welcome.
Toby.
The next case we have is NICN Asaba /4A to C /2015. Honorable Ebiakpo Zebiri and two others, and Burutu local government and one other. Any representations? Honorable Ebiakpo Zebiri and Burutu and two others versus Burutu local government and another. Any representation?
Yes, my lord.
Yes.
Yes, my lord. O.A. Udoro.
A.
O.A. Udoro.
ODORO.
No, UDO, my lord. UDORO, my lord.
Okay. Yes.
For the defendants.
Yes. Any appearance for the claimants? They are not there.
Yes, so my lord.
Okay. Very well. This is my judgment. I carefully considered the processes and submissions of the parties. I indicated earlier during the trial that the defendants objected to Exhibit CW1/1, CW1/3, and CW1/4 without stating the grounds of objection. I, however, directed the defendants to include the grounds of objection in their final written address for the court's consideration and determination. In their final written address, the defendants said nothing about Exhibit CW1/1, CW1/3, and CW1/4. I take it, therefore, that the defendants have abandoned their arguments to Exhibit CW1/1, CW1/3, and CW1/4. And some will be considered in the determination of this case, and I so hold. Going through the processes filed by both parties in this suit, I came across some spelling mistakes, jumbled narration of cases cited, and verb tenses incongruously presented. For instance, statement of fact should be statement of facts. It ends in an S, facts, not fact, F-A-C-T. Having been founded, and the having is H-A-V-E-N. Having been founded should be having been founded, H-A-V-I-N-G. Having entered into an agreement should be having entered into an agreement. The citation of UBN PLC versus Ubajimi ended at the year 2022 by the claimant at paragraph 6.5 of his final written address, tendered the citation incomplete or rendered the citation incomplete. Counsel, as a matter of the ethics of the profession, owe it to their clients to be punctilious in preparing processes in court. Editing and vetting of such processes is a necessary chore and must not be overlooked. A little time devoted to reading over a process would be all that it takes to win or lose a case. Seriousness and dedication is called for in all cases. See the dictum of Oputa JSC in Udofia versus the state. See also Darapale versus the state. The citations are in the judgment. I now move to the merit of the claimant's case. The law is, as the Supreme Court puts it in Gabriel Ativie versus Cabo Motor Nigeria Limited, is that a claim is circumscribed by the reliefs claimed. And the duty of a plaintiff, therefore, is to plead only such facts and materials as are necessary to sustain the reliefs and evidence to prove same. What then are the reliefs claimed by the claimant? Relief 1 is a declaratory relief that's the first claimant is entitled to perquisites as provided in the Remuneration Law 2000. Reliefs 2 and 3 are the main reliefs claimed by the first claimant. They are claims for monetary sums. The first is for a declaration that he is entitled to the sum of 4,104,333 naira 33 kobo as his unpaid perquisites duly provided for in the Remuneration Law 2000. And the second is for an order directing the defendants to pay to the claimant the sum of 4,104,333 naira 33 kobo as the perquisites for the claimant as clerk of the defendant's legislative house for 2 years of the 3 years tenure from May 1919 to June 2002. Relief 4 is a claim for 20% interest on the sum claimed from the date of judgment until the date the sum is finally liquidated. The defendant's response is that the claim against the defendant is founded on a law which the Delta State House of Assembly has no power to legislate on. That the 1999 Constitution clearly donates the powers to determine the appropriate remuneration for the claimants on the Revenue Mobilization, Allocation, and Fiscal Commission, as seen in item 32D of the third schedule to the 1999 Constitution. That what would entitle a plaintiff to a declaration is a right which the court is prepared to recognize, and which is validly made, prepared to give legal consequence to. See MPP versus INEC and Oko versus Nigerian Navy. Citations are in the judgment. Regarding Relief 1, where the claimant seeks the court's declaration that as a clerk of the first defendant is entitled to be paid his perquisites provided under the Remuneration Law 2000, the defendants maintained in paragraph 5.3 of their final written address that a declaratory relief is a discretionary remedy, which is not granted as a matter of course. That the court must be satisfied before granting it. That the claimant has a very strong and cogent case, both from his statement of claim and from the evidence adduced in the proof thereof. Cited Network Security Limited versus Dahiru. Declarations have a strict burden of proof and are granted only on the strength of the evidence of the claimant, not the weakness or absence of the evidence of the defendant. In fact, the admission of the defendant is not sufficient. See Muhammad versus Wamako and others. See Okoye and others versus Wanko, and SPDC versus Frontline Television. Dumets Nigeria Limited versus Wankoba. And others, relying on Bello versus Eweka and Motunwashe versus Sorungwe, throws more light in insisting that the claimant praying for a declaratory relief proves his case on his own evidence and not the evidence of the defendant. Claimant averred in paragraph 3 of his amended statement of fact that by a letter of the first defendant dated 24th September 1999, he was appointed clerk of the first defendant's legislative house, and he served in that capacity for 2 years. This averment is validated by paragraph 3 of his witness deposition on oath and Exhibit CW1/5, dated 24th September 1999, which is the letter of appointment as clerk of Burutu Local Government Legislative Arm. Paragraph 4 of his amended statement of fact, claimant averred that by virtue of the Remuneration Act 2000, he became entitled to salaries, remunerations, allowances, and certain perquisites for his tenure as clerk of First Defendants Legislative House. This is validated by paragraph 4 of his witness deposition. It's evidence in court and Exhibit C1, that is the law on remuneration, salaries, allowances, gratuities, and pension of certain public officers. On the issue of whether the first claimant, as the clerk of the First Defendants Legislative House, is entitled to be paid his perquisites as provided in the remuneration law, the Court of Appeal heard in Wokedi versus Anambra State Government and one and another per Agube JCA does. I'm quoting the Court of Appeal now, per Agube, it's a long quotation. Quote, this issue simply calls to question the extent or limits of the legislative powers or competence of the Anambra State House of Assembly as donated to it by the Constitution of the Federal Republic of Nigeria 1999 as amended, particularly sections 80 sub 1, 84, 124, and other sections thereof, nay, the Revenue Mobilization, Allocation and Fiscal Commission Act, Cap 392, Laws of the Federation of Nigeria 1990, to fix salaries of public officers and political office holders, which shall be charged upon the Consolidated Revenue Fund of the state. Section 4, sub 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, provides that, quote, the legislative powers of a state of the Federation shall be vested in the House of Assembly of the state, close of quote. Under subsection 7A, B, and C thereof, it states, the House of Assembly of a state shall have power to make laws for the peace, order, and good government of the state or any part thereof with respect to the following matters. That is to say, A, any matter not in the exclusive legislative list set out in Part 1 of the second schedule to the Constitution. B, any matter included in the concurrent legislative list set out in the first column of Part 2 of the second schedule to this Constitution, to the extent prescribed in the second column opposite thereto. And C, any other matter with respect to which it is empowered to make laws in accordance with the provisions of this Constitution, close of quote. There is no dispute as the learned counsel for the appellant has argued that a councillor is a political office holder, but whether he comes within the purview of those officers whose salaries shall be determined and charged upon the Consolidated Revenue Fund of the state by the Revenue Mobilization, Allocation, and Fiscal Commission, so as to warrant judgment being entered in his favor, is another question entirely. In this wise, it is necessary to seek for guidance from the Revenue Mobilization, Allocation, and Fiscal Commission, Cap 392 Laws of the Federation of Nigeria, whether the appellant is actually a beneficiary. Section 6 of the Act, which stipulates the powers of the Commission, states thus as regards remuneration. 6.1. The Commission shall have power to D, determine the remuneration appropriate to the holders of the offices as stipulated in parts A and B of the first schedule of the Act. Part A thereof makes no mention of a councillor as one of those public officers or political office holders to benefit from payment of salary and emolument from the Consolidated Revenue Fund, and whose salary shall be fixed by the Revenue Mobilization, Allocation, and Fiscal Commission. The learned counsel for the appellant has referred us to Section 6 sub 1F of the Revenue Mobilization, Allocation, and Fiscal Commission Act, which provides that the Commission shall have power to F, discharge such other functions as may be conferred on it, that is the Commission, by the Constitution of the Federal Republic of Nigeria, and this Act, or any other act of the National Assembly. This provision in itself is clear and unambiguous, as it only expands the scope of the Commission in respect of matters that are not connected with the fixing of remuneration of persons so mentioned in Part A and B of the first schedule of the Act. In other words, those other functions that the Commission ought to perform, or upon which extra power may be conferred on it by the Constitution, the Act, or any other act of the National Assembly, do not encourage expanding the scope of political office holders or public officers whose names have not been mentioned either by the Constitution, the Act, Cap 392 itself, or any act of the National Assembly. Even then, if the scope is to be expanded in the clear and precise and lucid words of provisions of the Act, only the Commission's Act itself, which is an act of the National Assembly, the Constitution, or any other act of the National Assembly, can expand the scope or powers thereof, and not an inferior legislative house of assembly. it would appear there was a legislative device to deliberately exclude political office holders like local government chairmen, speaker/leaders of legislative houses, and councillors who are legislators as of right on their local government tier of government. However, they are not legislators properly so called as envisaged by the Constitution. To clear the point, I shall invite Section 318 of the Constitution, which the interpretation section of Revenue Mobilization, Allocation, and Fiscal Commission Act, which also makes reference to public service of the Federation and that of the state. Section 318 sub 1 states that, quote, in this Constitution, unless it is otherwise expressly provided or the content otherwise requires, legislative house means that Senate, House of Representatives, or a House of Assembly. The Legislative Council of a local government is not mentioned by the Constitution. So by extension, the councillor is not recognized by the Constitution as member of a legislative house properly so called. From the foregoing, there is no doubt that the purported claims by appellant for unpaid arrears of salaries, remunerations, and severance allowance based on the recommendation of the Revenue Mobilization, Allocation, and Fiscal Commission and the Anambra State Public Salaries and Remuneration Law number 7 of 2001 are unconstitutional, as both the Commission and the House of Assembly of Anambra State lack the powers to prescribe and fix salaries and remuneration for councillors who are not mentioned in Section 124 sub 4 of the Constitution and Section 6D of the Commissions Act, as those whose emoluments and remunerations, as well as allowances, shall be charged upon the Consolidated Revenue Fund of Anambra State. The learned trial judge was therefore right in so declaring Law number 7 of 2001 of Anambra State as unconstitutional and therefore null and void, and I so hold. Close of quote. I did say the quotation is a long one. The first claimant had argued paragraph 6.20 and 6.21 of his final written address that under Section 124, the holder of offices did not include the claimant who is a holder of office under the local government council. That Section 124 sub 4 of the 1999 Constitution instead listed the said officers. That item 32D of the third schedule again did not also list the claimants who is a holder of office within the local government council. It is therefore pertinent to conclude that on that ground alone, the claimant relief 1 must fail for non-proof. Relief 1 therefore fails, and I so hold. The claimant went on and submitted in paragraph 6.22 of his written address that a community reading of section 124 sub 1 item 32D of the third schedule of the 1999 Constitution did not curtail the powers of the Delta State House of Assembly to make laws on the remunerations, etc. of public holders or public office holders of the local government council. The principle is well settled in the Constitution of statutory provisions that where in the construction of statutory provisions that where a statute mentions specific things or persons, the intention is that those not mentioned are not intended to be included. See Federal Republic of Nigeria versus George Osahon and others. It is therefore axiomatic that where councillors of a local government council, not to talk of a clerk, are not mentioned in section 124 of the 1999 Constitution, a State House of Assembly cannot go out of its way to make such an incongruous piece of law. Such a piece of legislation must be struck down suo motu. I accordingly declare the remuneration, salaries, and allowances, gratuities, and pensions of certain public officers and bodies law 2000 passed by the Delta State House of Assembly and deemed to have come into force on 19th February 2002 as unconstitutional and therefore null and void.
As the court pleases.
The first claimant, relief 1, praying for a declaration that by virtue of the remuneration law 2000 is entitled to be paid his entire perquisites as provided under the said law cannot be sustained. Same is accordingly dismissed.
As the court pleases.
I shall nevertheless proceed to resolve all issues brought before the court on merit as enjoined by the Supreme Court in Edem versus Cannonballs Limited. In the event that I am wrong, by reliefs 2 and 3, the claimant in, that is Austin Ibapike Esquire, is claiming for 4,104,333 naira 33 kobo as the perquisites of the clerk of the Delta of the defendant's legislative house for 2 years of the 3-year tenure from May 1999 to June 2002. Pleadings For this claim are to be found in paragraph 7, 9, and 10 of the statement of facts, amended statement of facts. For ease of reference, these paragraphs provide as follows. 7. By virtue of the Remuneration Law 2000, the various heads not paid for by the defendants amount to the sum of 6,160,500 naira. However, broken down for 3 years as follows, which is computed based on the claimant's annual basic salary of 370,000 naira. Accommodation, transport, utility, domestic, and entertainment are broken down. That is what amounts to 6,160,500 naira. In view of the fact, paragraph 9, in view of the fact that one Mr. Asu Eteku, the claimant occupied the office for the said tenure, the money was shared between the claimant and the said Mr. Asu Eteku at a ratio of 2:1, with the claimant taking two parts and Mr. Asu Eteku taking one part. As the claimant, and the said Mr. Asu Eteku spent 1 year, 2 years, and 1 year in office respectively. The claimant sought reliance on a copy of the first defendant's letter evidencing the 2.1 sharing, 2-to-1 sharing ratio, with a computation containing the total amount accruing to both the claimant and Mr. Asu Eteku, which is totally incorrect. Paragraph 10. Claimant averred that by the 2-to-1 ratio, sharing ratio, he is entitled to 4,104,333 naira 33 kobo from the 6,160,500 naira. For the heads not paid for, by virtue of the Remuneration Law 2000. So supporting the position in words similar to the pleadings, paragraph 7.9, paragraph 7, 9, and 10 of the witness statement on oath of the claimant. The law is that a claim for special damages must be pleaded and particularized so that the defendant will know what he is meeting. By 7-Up Bottling Company, PLC versus Augustus, the claims for gratuity, pension, housing fund be strictly proved. Each of the said items must be proved to the satisfaction of the court, as the court is not entitled to make its own estimate of same. It must be proven with credible evidence, and without such proof, no special damages can be awarded. C. Taylor versus Ogenovo, Joseph versus Abubakar, AG Leventis Limited versus Aku, Osuji versus Isiocha, Otaru and Sons Limited versus Iris. The citations are in the judgment. The claimant averred, paragraph 8 of his amended statement of facts, that the first defendant agreed with the computation of 6,160,500 naira. Paragraph 7 of the amended statement of facts of the various heads not paid for the first by the first defendant in the defendant's letter of 28 October 2003, the Honorable Commissioner, Ministry of Local Government and Chieftaincy Affairs. But the figures the first defendant ascribed to transportation, total amount, salary earned, arrears paid, and balance amount were, however, incorrect because the first defendant computed transport for 1 year rather than for 3 years as provided by the law. What all of this means is that the claimant did not plead his accommodation, transport, utility, domestic serve, and entertainment allowances, but rather left it to the first defendant and was contented on passing the buck to other authorities for the discordant figures. What is certain, therefore, is that the claimant did not plead his accommodation allowance, he did not plead his transport allowance, he did not plead his utility allowance, he did not plead his domestic staff allowance, he did not plead his entertainment allowance. And if, as claimant stated in paragraph 7 of his amended statement of facts, that the allowances if, as claimant stated in paragraph 7 of his amended statement of facts, that the allowances purportedly computed were based on his annual basic salary of 370,000. One wonders where that is pleaded in his amended statement of facts or deposed to in his witness deposition on oath. Exhibit CW1/5, dated 27 September 1999, through which the claimant was appointed clerk of first defendant legislative arm, does not even have basic salary or any allowance stated therein. The law is that evidence without pleading goes to no issue. Seashell Petroleum Development Company of Nigeria Limited versus Kwame Anba. In like manner, Pleadings without evidence go to no issue. See Ifeta versus SPDC. It follows that counsel's submission, no matter how brilliant, is no substitute for pleadings and evidence. And it is not the duty of the court to fix defective pleadings. As His Lordship 2 JCA puts it in Chief James Onyewuke versus Modu Sule, the trial judge should not embark on a voyage seeking to repair the damage caused by counsel in failing to plead material facts necessary to obtain judgment in the temple of justice. Says courts are not carpenter's workshop where judges toil to mend defective pleadings. Claims for monetary sums by the claimant must therefore fail and so are hereby dismissed. In like manner, it is not the duty of court to fill gaps in pleadings. See Sunday a Major versus National Institute of Pharmaceutical Research and Development. Relief 2 of the first claimant phase, and so it's hereby dismissed.
As the court pleases.
Relief 2, reliefs 3 and 4 are hinged on the grant of reliefs 1 and 2, which are declaratory reliefs. In the circumstance of the dismissal of reliefs 1 and 2, it stands to reason, therefore, that reliefs 3 and 4 cannot be granted. Reliefs 3 and 4 fail, and so are hereby dismissed.
As the court pleases.
Honorable, wait. Mhm. CW2, that is Honorable Ebiako Ezebiri, had tendered Exhibit CW1, 3, 4, and 5 in support of his case. Stated that he made reference to a computation drawn up by himself on his entitlements. See Exhibit CW2/1. Under cross-examination, he stated that he was paid for only 1 year entitlement in the consent judgment, and he is in court for the non-payment of the 2 years he served first defendant counsel. That aside his salary, he never received allowances during his tenure. Paragraph 9 of his amended statement of facts, he averred that what the first defendant owes him For the subheads, he highlighted is 6,212,880 naira. However, in paragraph 10 of his amended statement of facts, he averred that by virtue of the Remuneration Law 2000, which governs his entitlement, is entitled to the sum of 6,528,000 naira, which were excluded from the computation leading to the judgment in W/6/2003 and W/9/2004. The claimant would proceed to state in paragraph 11 of his amended statement of facts that most of the above figures and headings were acknowledged by the first defendant in their letter to the Honorable Commissioner, Ministry of Local Government and Chieftaincy Affairs, Asaba, dated 28th October 2003. But the figures the first defendant ascribed to furniture, total amount, salary, and arrears paid, and balance amount are, however, not correct. The question then would arise as to what is actually correct. The claimant then averred in paragraph 14 of his amended statement of facts that the first defendant owed the claimant 6,212,880 naira 30 kobo from the various heads that were partly paid as pleaded in paragraph 9, and 6,528,000 naira from the various heads excluded by the first defendant as pleaded in paragraph 10 above. The sum of which is 12,740,880 naira. But what is reflected in paragraph 10 is 6,528,000 naira, which is at variance with what is stated in paragraph 9. That is 6,212,880 naira 30 kobo. The discordant figures in paragraphs 9 and 10, in my humble view, would not separately make the sum of 12,740 naira 880 kobo claimed by the claimant. What all of this shows to me is that the claimant did not plead his transportation allowance. He did not plead his utility allowance. He did not plead his domestic staff allowance. He did not plead his entertainment allowance, maintenance of staff quarters allowance. He didn't plead his newspaper allowance. He did not plead his motor vehicle allowance. He did not plead his personal assistant allowance. He did not plead his wardrobe allowance. Neither did he plead his responsibility allowance or research allowance and committee chairman allowance. What the claimant computed in Exhibit CW2/1 as his computation of remuneration, salaries, allowances, gratuities, and pension of past political office holders of Burutu Local Government Council between May 1919 to June 2002 under the Remuneration Act 2000 is 17 million 358 naira, 58,000 naira. Exhibit CW 2/1 is not reflected in the claimant pleadings or deposition on oath or at all. As I stated earlier, the law is that evidence without pleading goes to no issue. In like manner, pleadings without evidence go to no issue. See Onabule versus Sanya, see Banyoko and others versus Ogunlaja. See UBN PLC versus Astra Builders West Africa Limited. See Yanwale versus Odunsami. The law is tried that submissions of counsel, no matter how alluring, can never take the place of legal proof. In the light of all that I have been saying, Relief 1, seeking the court's declaration that by virtue of the remuneration law of 2000 of Delta State of Nigeria, claimant as a past political office holder / councillor of the first defendant is entitled to be paid 12,740,880 naira as his allowances is not allowed. It fails for lack of proof and so is dismissed.
As the court pleases.
Since the declaratory relief 1 has failed, there is no point considering reliefs 2 and 3, which is the claim for 12,740,880 naira and 20% interest thereon. They both fail and so are dismissed.
As the court pleases.
In all, the second claimant's case fails in its entirety and it is accordingly dismissed. Jonathan Bodon Wekiri Wurus testified as CW, attended exhibit C1, C2, CW2, CW3, CW4, CW5, and CW6. In his issues for determination, claimant posits whether he has not proved his case on the balance of probabilities as required by law and entitled to judgment. The claimant then submits that in the absence of a defense, the defendants are deemed to admit the claims of the claimant. Cited Nigerian Bottling Company, PLC versus Chief Uzoma Ubani, Mobi Producing Unlimited, and another versus Chief Monoko and others, versus on HRA, Tebuna, and others. It's a mixed breed there. Claimant seeks the court's declaration that by virtue of the Remuneration Law 2000, is entitled to be paid 14,937,916 naira as his allowances, and same be so ordered by the court with interest thereon. It might not have occurred to the claimant, that is J.B. Wurz, that his claims are for monetary awards, which, as I have exhaustively regurgitated in this judgment, are special damages and must be specially pleaded and particularized, and that it is further expected as a matter of law that the claimant should prove the heads of claim with exactitude. Special damages are such a loss as the law will not presume to be the consequences of the defendant's acts, and as such must and will be given on the mere preponderance of evidence as blandly pontificated by the said defendant. Relief 1 is a claim for allowances of the sum of 14 million $937,916. In proof of this sum, the claimant in paragraphs 4.9 and 14, in paragraphs 4, 9, and 14 of the amended statement of facts pleaded that by Schedule 3 of the Remuneration Law of 2000, he became entitled to 17,466,500 naira for his tenure of 3 years, beginning from May 1999 and ending in June 2002. That first defendant in the computation only computed 1 year, amounting to 1,279,584 naira, instead of 3 years, amounting to 3,825,000 naira for severance gratuity, leaving a balance of 2,545,416 naira. That by virtue of the remuneration law, is entitled to 12,392,500 naira, which was excluded from the computation leading to the judgment in W/6/2003 and W/9/2004. The claimant then averred in paragraph 6 of his amended statement of facts that he shall rely on the defendant's computation dated 26 August 2002 of the entitlements due to past political officers of the first defendant, which included that of the claimants between May 1999 and June 2002. If, as argued, by the claimant in paragraph 8 of his statement that the computation of the sum in Exhibit C3 became judgment. Where is the evidence that the first defendant did not include transportation, utility, domestic staff, entertainment, furniture allowance, personal assistant, motor vehicle maintenance and fueling, leave allowance, constituency allowance. The pleadings are dead silent on Exhibit CW2/3 and details of the terms of settlement dated 16th April 2003 and the sums paid therefrom to the claimants. In all of this, claimant did not state in detail what is due to him in Schedule 3 of the Remuneration Law 2000 and how he became entitled to the sums therein and the mode of calculation. He might have expected the court to go on a voyage of discovery. In other words, how did the claimant come by the quantum of the sum donated to him by Schedule 3 of the Remuneration Law 2000? 7-Up Bottling Company PLC versus Augustus Supra is specific in holding that proof of special damages is strict and must be to the satisfaction of the court. I am not satisfied with the evidential value of Exhibit CW3, CW2/3, and the glossy reference to Schedule 3 of the Remuneration Law 2000, especially how the said law entitled the claimant to 17,846,500 with exactitude. Accordingly, I hold that Relief 1 has not been proved since it hinged on Exhibit CW3, CW2/3, and the Remuneration Law 2000. It is accordingly dismissed.
As a court pleases.
Relief 2 and 3 are consequential reliefs that must also fail. They are accordingly dismissed.
As the court pleases.
On the whole, I find no merit in the claimant's case. They all fail, and so are hereby dismissed.
As the court pleases.
Judgment is entered accordingly, and I make no order as to cause.
As the court pleases.
Yeah. That will be all. The court will rise.
Abetino. Apa? Tidak apa tidak apa tidak apa tidak